Hello everybody and welcome to our first lesson in a new series, a new lecture series on the study of public international law. Now, this video is going to be an introduction to the subject of public international law, and you might think that this is going to be a little bit different to the ordinary lessons that we do on this channel, and that's because I'm going into far more detail in these. These are more like lectures than they are actually bite-sized lessons. And I would like to begin, if I may, with a short video, for us to quickly watch.
Virtually certain 2024
could be the planet's hottest
year on record.
We can see that we're not ready for the storms that we're receiving now, and it's going to be worse in the future.
Those in the industry call it a perma-crisis, a sense that the world is lurching from one extreme event to another.
Russia's war in Ukraine enters its third year.
Tens of thousands have been displaced across the Haitian capital.
The humanitarian crisis in Sudan is worsening.
South Korea's parliament voting to impeach President Yoon Suk-yeol
over his short-lived declaration of martial law.
Israel has expanded its bombardment of Lebanon, striking new areas.
It's alleged that Netanyahu Gallant used starvation as a tool of war.
So, fundamentally then, what is the thing that, or what are some of the things that links all of these world events together? That was from the Vox 2024 video. I dread to think about what the 2025 video will look like. Well, there are a few things of note. They don't paint a particularly positive picture about the world and its future. But more importantly for our purposes, they are all events and situations that are fundamentally international in character. These world events might include war in the Middle East, in Ukraine, in the Congo, the climate crisis, the Trump tariffs. All of these things will affect, in one way or another, everybody on planet Earth. You might think, for example, that a war in a faraway land has no impact on you, but it does. All of these things are very much interconnected in the globalized world that we currently live in. Now, why are you interested in international law? I would encourage you to just pause this video and to think about it, maybe even write down what you say and what you think about this particular question, because it's a thing that I've thought about for the better part of half a decade at this point, since completing my master's degree in international law back in 2021 and spending some time as a PhD researcher in international law. Some of you might take an interest in international law because you're motivated by a desire to improve human rights compliance on a global level. Some of you may be interested in the way that law regulates the conduct of belligerents in armed conflict. Some of you may be interested in the climate crisis, undoubtedly an issue of international law. And this is obviously evident given the fact that very recently the ICJ, the International Court of Justice, has issued an advisory opinion on climate change and the climate crisis. Some of you may be interested in the ways the global economy works and the way that trade and investment and finance is regulated. I honestly couldn't tell you what the reason is for my interest in international law. Perhaps it is just a mixture of all of the above. But regardless, what I will be doing is writing and producing a few, what will probably be 100 lectures or so in all of these different areas of international law, explaining and providing insight into how the international legal system works and how, more importantly, we might be able to make it better. And so, while it is the case that international law has existed in some way or another for many, many centuries, maybe even millennia, our modern conceptualization of public international law is relatively new. It's a relatively new phenomenon. The first use of the phrase public international law dates back to Jeremy Bentham in the 1780s with his introduction to the principles of morals and legislation. The majority of rules that we rely on in international law today derive out of the end of the Second World War and the establishment of the global international order which emerges in the second half of the 20th century. Even more rules can be encompassed if you then start to think about the role that the League of Nations plays after the end of the First World War. But broadly speaking, my point is that the development of a lot of the rules of public international law that we think about today basically come out of the 20th century in one way or another. Now, by international law, I am of course referring to public international law. Public international law as delineated from private international law. The idea of private international law concerns the legal relation between the choice of forum, the choice of law, or sometimes described as the conflict of laws as well. Public international law, by contrast, then, concerns the legal relations that are established between states. It is, of course, a vast and increasingly expansive area of the law, one with many different subcategories. Public international law, for example, can concern human rights, it can concern trade and economic relations, it can concern issues relating to rules as applied to the high seas and the law of the sea, or to the law of outer space. It covers disputes which are peaceful in nature, as well as those circumstances in which states have to resort to the use of force. And so if this is the case, if you can really broadly delineate international law into all of these different increasingly expansive areas, what are the rules which unite these seemingly separate areas of law? What are the principles that bring all of these different areas together? Well, these are the principles of public international law, the subject of this lecture series. And so in this first lecture, what I'm going to do is take an introduction to the subject of public international law. This will involve introducing to you a number of important features, a number of key terms and basic terminology, as well as some basic international legal theory, before we then finish by expanding on and outlining the scope of this series of lectures. The ideas and principles that you will learn in this series of lectures will help to equip you with the necessary understanding of how the international legal system works and operates, but also in any of the areas of international law that you might be interested in, these principles all are applicable and are all very important. So when we in the future start looking at law of the sea, when we start looking at human rights in more detail, or the environment, or the use of force, we will be relying on the basic principles of public international law that we have explored in this lecture series. And so I guess an initial starting point might be to think about the nature of international law and to examine by asking the first question, which is a sort of theoretical question, which is, what is international law? Is international law even law at all? Is it even law? Well, the claim that international law is not law at all, is in fact not even a type of law that we could have any consideration for, was a popular idea for quite a great amount of time. In the late 19th and early 20th centuries, there were a number of legal philosophers who would be broadly categorized as the early legal positivists or the classical positivists, people such as Jeremy Bentham, and more importantly, people like John Austin. Austin himself specifically believed that law constitutes a number of rules which are established by some kind of sovereign, okay? Now, the sovereign on this view might be the monarch, they might be some kind of legislative, central or legislative authority or executive authority, such as Parliament in Great Britain. But on this account, due to the lack of a sovereign, Austin argues that international law is in fact not law at all, or at least not law in the same way as the law of domestic jurisdictions. He defines law as very different. He defines international law very differently to any other type of domestic law itself. So on that account, international law is in fact not law at all. So let's finish our conversation and let's move on. Well, obviously that's not what the case is. one may be able to alter the original claim that law isn't in fact law by suggesting a slight alteration, making a slight change. And here I want to refer to you to a book by Goldsmith and Posner, The Limits of International Law, where they say that, quote, international law lacks a centralized or effective legislature, executive, or judiciary. It favors the powerful states over the weak states. It often simply mirrors ex-ante international behaviour, and that it is sometimes violated with impunity. And that's certainly an interesting consideration. It's also certainly true, and one of the common criticisms that many throw at public international law. Since there is no unified authority or any real ability for enforcement, then surely public international law just relies on the goodwill of states to uphold and to enforce the rules that they are bound to enforce in accordance with these basic principles. And so, on this account, it might then be impossible to divorce international law from the study of international relations. It could just be that international law isn't law in the same way, it is just a type of international politics, or the language of international relations is that of legal principles such as treaties and custom, etc., etc. Now, fundamentally, we will talk about the relationship between international law and international relations as its own separate lecture in the future, but this may also be one of the reasons why international law has not in fact occupied the minds of many of the great jurisprudential theorists in the past. If I cite to you, for example, a paper by Liam Murphy, they made the point that, quote, with the exception of Hans Kelsen, whose systematizing and unifying intellectual inclinations made the topic inevitable for him, Hans Kelsen, of course, being somebody who dealt quite extensively with international law, legal philosophers have not thought much about international law over the past century. So, according to this view, then, international law hasn't really occupied the minds, should I say, of many of the legal philosophers in the past. But I would go so far as to argue that John Austin's theory of legal positivism not only underestimates international law, but it also overestimates or oversimplifies the philosophical understanding of domestic legal systems. As Malcolm Shaw notes in his textbook on international law, quote, the idea of coercion as an integral part of any legal order is a vital one that needs to be examined in the context of international law. Now, today, most people hold the view that international law is indeed law, but it might not be law in the same way as the law of a domestic legal system, for example. This is not to suggest that it is any less important or any less worthy of study. According to Judge Alvarez in the Corfu Channels case, quote, a law may be established and become international. That is to say, binding upon all nations by the agreement of such nations to be bound thereby. The resistance of a nation to a law to which it has agreed does not derogate from the authority of the law, because that resistance cannot perhaps be overcome. And so the reality is such that there are customs, that there are traditions, there are moral principles, there are legal rules and actions which states exist among the world communities in their daily socio-economic and political relationships. Ultimately, what makes law law is not a question that really has an answer. In order to correctly ascertain whether or not international law can truly be said to be law, one would have to definitively answer the question of what law is in and of itself. And since this is not going to be achieved in the space of this lecture series, since it hasn't been achieved in the space of the 1,000 or so years of legal philosophy on this topic, it's probably pertinent to move on. Another question, and despite moving on from the aforementioned conversation, I still think it's important to explore some of the key practical differences that might exist between domestic law and international law. I shall be using the English legal system to illustrate my points, since this is a channel that is dedicated to teaching mostly the English legal system, or at least up to now it has been, and because that's the system that I'm most familiar with. If you come from a different background or from a different jurisdiction and you have knowledge of that jurisdiction and background, then feel free to substitute your own knowledge and your own understanding accordingly in this way. So, by and large, when one thinks of the delineations between international law and that of the domestic legal systems, the first place they will turn to is the question of enforcement. In a domestic legal system, if, say, you were to commit some kind of crime, it is likely that the legal system will enforce its rules through its enforcers. In England and Wales, this will be some kind of police force in your area. They will make an arrest. They will be the ones who investigate potential wrongdoing, and if they believe it is necessary to do so, and in line with CPS guidance, they will be the ones who will charge you for the alleged crime that you have committed. Now, this brings us to an interesting question. There is no international police force. There are arrest warrants that may be issued in accordance with international law, which we will get to in a second, but there's no way of enforcing those arrest warrants except for the duties and obligations of states to uphold those rules themselves. It's almost like you, as an individual, have a duty to uphold the same rules and laws of the criminal law, for example, against yourself without the need for a police force to exist. Now, this brings us to our next major delineation that we can make between these two types of regimes. In domestic law, there is often this single unified system to which everybody is subject to through their jurisdiction. So, for England and Wales, for example, we have things like the common law, aptly named since it is a body of law which is common to all who live in this jurisdiction. And what this does is enshrine something of an equality of application of domestic law. The principles of negligence, for example, in the law of tort, or contracts, or crimes, will apply to everybody in England and Wales, regardless of your class, your gender, your race, or your sexual orientation. In international law, though, this idea of equality of application is a little bit more complicated, since there are parts of international law which are in fact universally applicable to all, and we will get to that when we examine the sources of international law in more detail. But importantly, there are huge parts of international law which do not apply equally to everybody, and by everybody I'm talking about by reference to states, of course. States are the primary actors in international law, something we will get to again in future lessons. If, for example, you as a state, let's say, have not ratified a particular treaty and the provisions of those treaties do not form part of what we would describe as customary international law, then this means that you cannot be bound to those treaties' obligations. Take the example of the United States. The United States has had a history of selective application of international law as it applies to her own nationals. The US, for example, was deeply and intimately involved in the establishment of the Rome Statute and the Rome Conference in 1998, which is the instrument that establishes the International Criminal Court. However, due to a whole host of reasons, including the US's own sovereignty issues, as well as a change in presidential administration in the early 2000s, the US never ratified the Rome Statute. And so, therefore, the jurisdiction of the International Criminal Court is limited only to US nationals who commit international crimes in the territory of a state who has accepted jurisdiction. And even that is subject to challenge, as we will see when we look at international criminal law in its own separate series of lectures. This does raise an issue then, doesn't it? It raises an issue about an even playing field. And worse still, when we start to think about the relationship between international law and colonialism, international law and international relations, and international law and global power and hegemony, this influences the playing field even more. The question of how hegemony and global power and the role of international relations in that question makes equal compliance a difficult proposition to defend. More on this in future lectures. The next point I want to make is a point about pessimism and a point about nihilism in relation to international law, because some people have argued that there is something of a death of international law. And it's at this point that I want to give you another video to illustrate this point in a little bit more detail.
Today, 17th of March 2023, the International Criminal Court has issued 2 warrants of arrest in the Ukraine situation for Vladimir Putin, President of the Russian Federation, and for Maria Lvova-Belova, Commissioner of the Russian President for Children's Rights, for the alleged war crimes of deportation of children from Ukrainian occupied territories into the Russian Federation. It is forbidden by international law for occupied powers to transfer civilians from the territory they live in to other territories. Children enjoy special protection under the Geneva Convention. This is an important moment in the process of justice before the ICC. The judges have reviewed the information and evidence submitted by the prosecutor and determined that there are credible allegations against these persons for the alleged crimes.
So, fundamentally then, what we're talking about here and what we're seeing here is an example of something that was issued 2 years ago, where the International Criminal Court issued the following statement with regards to the Russian invasion of Ukraine. Now, take away for one second this question of immunities of heads of state, which some of you who have already studied international law or may have a basic familiarity with international law might know about already. In that video, the individual in question who was citing the arrest warrants for a number of people included not just Vladimir Putin. But 2 years later, nobody in the Russian Federation has faced criminal liability for the illegal invasion and for the crimes against humanity committed in the state and the territory of Ukraine. I could just as equally, make a point about arrest warrants for the Israeli Prime Minister Benjamin Netanyahu and the former Defense Secretary Yoav Gallant, as well as the various members of the armed group Hamas in relation to the Israeli-Palestinian conflict. Nobody has faced any kind of legal resolve or legal punishment for the alleged crimes committed there, nor has anybody had any kind of retribution or any kind of punishment for the alleged crimes committed against women in Afghanistan, which was another recent arrest warrant that was issued by the ICC. And so this raises the question then, what's the point of this? What is the point of issuing arrest warrants if we know, and we all sort of pessimistically might know, won't go anywhere and won't do anything? Well, a few weeks ago, The Guardian published an article titled, "Are We Witnessing the Death of International Law?" And I will put it in the description below. In it, they say the following, quote, "We are not in a period of downturn. International law will not disappear, but its institutions will probably continue to lose credibility and rulings will carry less weight. The degradation of international law will be accompanied by the parallel erosion of the rule of law within states." Why is this then a recent development? Well, for the most part, it's not. The Russian invasion of Ukraine, or violations of international humanitarian law in Gaza, may seem to many scholars and activists today to be a sign of the decline of international law. But scholars and lawyers working 20 years ago might have said the same thing about the illegal invasion of Iraq, or the genocide in Rwanda, or genocidal acts committed in the former Yugoslavia, or even war crimes committed in the Russian invasions of Chechnya. International lawyers in the 1960s may have lamented the same concerns with reference to the US invasion of Vietnam. Within specific fields of international law, there have been debates about this for years. A very important book by J.Linarelli, Salomon and Sornarajah, titled The Misery of International Law, makes reference to this and opines this fact with specific reference to the global economy, so the idea of international economic law. They say, quote, "The international economic order is unjust. It continues to reflect the dominance of certain states and to favour their interests while upholding a system of ideas and practices that extends their privileges. The international economic order cannot be justified on grounds of respect for persons, particularly those it harms or for whom life prospects are diminished." Now, the study of international economic law and the injustices associated with that particular body of law is something that I will be getting to in future videos as well. But even though Sornarajah, Salomon, and Linarelli are making a point here about the global economy, the full title of the book is The Misery of International Law, Confrontations with Injustice in the Global Economy, it might be apposite to make the argument that this is a principle, these are basic ideas that don't just limit themselves to international economic law, but they are extended to all areas of international law, whether it be international humanitarian law, the law on the use of force, international criminal law, environmental law. And so many see these statements made by international lawyers and scholars, and many more still, such as activists, as evidence that international law is dead or is dying. But as I've already noted, this is not a recent development. Now, fundamentally, while it may feel as though international law is under attack at a greater rate than usual right now, it is not the case that international law, the death of international law, is a recent development, at least in my opinion, or that its rules are ambiguous to the degree that they are meaningless, as some even international lawyers try to argue. Take the recent example of Israel and the United States launching their airstrikes against Iran, and the debate that unfolded there about the legality of the use of force. Now, in my notes, I've cited a bunch of blog posts between a number of different international legal scholars on this question, and it is a saga, essentially. It is a saga of international lawyers trying to make the argument that the Israeli and the United States joint operations, such as Operation Rising Lion, against Iran was a right to self-defense case, and therefore was acceptable or it was defensible under the UN Charter. And then you have people on the other side saying that this is, of course, not the case. Such ambiguities then, and such debates back and forth between legal scholars, may give the impression that international law is somehow inconclusive on major issues of global importance. But this isn't true. International law is very clear in almost all areas, and it is very conclusive on all of these issues. This is not to suggest that there are not hard cases. There are always hard cases in international law. Law is always developing. The global system in which we live has always got new challenges and new issues for which the law applies, but there is no point at which the law is not applicable, or it is ambiguous to the point of its meaninglessness. Where ambiguities exist, they are no more numerous or unresolvable than in any other form of legal adjudication. Just because there are ambiguities, for example, in the English legal system that the Supreme Court has to resolve, does not mean that the English legal system is dead or is dying. The truth is then that international law is vital. In an increasingly globalized world, the regulation of economic affairs, the regulation of the environment, public health, wars and armed conflict, human rights are all issues which cannot be achieved without international law, without international agreement. Again, citing Malcolm Shaw, it is important to realize that states need law in order to seek and to attain certain goals, whether these be economic well-being, survival and security, or ideological advancement. The system therefore has to be certain enough for such goals to be ascertainable, and flexible enough to permit change when this becomes necessary due to the confluence of forces demanding it. Fundamentally then, because we live in a world in which things cross borders, climate change crosses borders, public health issues crosses borders, wars often involve the crossing of borders, especially international armed conflicts. This means that international law has to exist. It has to exist in one way or another, because without it, without international law, we are just a bunch of island states that have no way of regulating the relationship that we have with each other. And this would lead to chaos and anarchy, as some argue is the case. However, I fundamentally disagree. With this in mind then, this lecture series will examine some of the most foundational concepts in public international law, and it will do so from as an advanced perspective as possible. Okay, I'm not going to be doing introductory issues here. We're going to be getting into it really going in from the deep end. It will aim to be more than just some kind of doctrinal analysis of the legal system as it exists lex lata, as it exists at the moment, but also from a theoretical and even a critical perspective. And with this in mind, then, we are going to be broadly delineating our lectures into the following topics. This might be subject to change. I might put some together or maybe add some more in here and there. But for the most part, this is what we are going to be doing, and this is how we are going to be studying it. So we're going to begin in the next lecture by talking about the history of international law, and we're going to be putting the issue of colonialism and the question of colonialism and empire front and centre of that debate and that conversation. Talking about international law's quite messy history might be important to understand how the system works and operates to this day. We're then going to dive quite deep into some quite interesting theoretical principles associated with international law, and this will be the case for the next 4 lectures. We will talk about constitutional approaches to international law. We will talk about the relationship between international law and international relations, the relationship that I mentioned earlier on, and we will also talk about the question of global justice and the issue of global justice as an area of study and the conversation that can be had with international law and global justice, before we think a bit more practically about the question of fragmentation, one of those areas of international law that is unique to this type of legal system, given the domestic legal systems don't have this kind of fragmentation. From there, we're going to spend some time talking about where international law in fact comes from. We will begin by looking theoretically at the sources of international law, before then diving into all of those things in more detail, talking about the law of treaties, talking about custom, talking about general principles, as well as subsidiary sources, the subsidiary sources being, of course, judicial decisions and the writings of the highly qualified publicists. We will talk about some of the ways in which these sources are able to crystallize into or are able to form into quite substantive obligations for all states, looking at erga omnes obligations and obligations jus cogens. We'll then start thinking about states in more detail, and that will be the subject of lectures 12, 13 and 14, because we will begin by thinking about what constitutes statehood, what constitutes state recognition, and then also the issue of state succession, before moving on in lecture 15 to looking at the relationship between international law and municipal law or domestic law. The final 4 lectures are going to be concerning some of the more subsidiary topics within international law from a general perspective. So we will talk about the issue of sovereignty and jurisdiction. We will talk about the issue of immunities as well as state responsibility, before finally examining the ways in which the international legal system deals with the settlement of disputes. And then the final lecture will examine the challenges and the future. If there are any additional topics you might think that I have missed in this series here, in this lecture series, then please do let me know and I might add them in and do some more research onto those as well. Put that down in the comments down below. But I hope you've enjoyed this video, this introductory video to public international law, and I hope to see everybody in the next lecture when we start talking in far more detail about the history of international law, and we start to dive into some of the more theoretical approaches associated with this area of study.